Your Lordships, I'll be making submissions on behalf of the appellant along with my learned junior, Mr. Butler. My learned friends, Mr. Jamar and Mr. Bennett, will be making submissions on behalf of the respondent. Would your Lordships care for a brief summary of the facts of the case?
No, I think we have them. I think everybody is seated.
Then, with your Lordship's permission, I shall make submissions on the first round of appeal, namely that the contract should not have been binding until Gandhi received notice of acceptance. I shall now move to my first submission, that it was not reasonable to accept the offer via the postal service, therefore the postal rule is inapplicable. Do I have your Lordship's permission to dispense with citations?
Yes.
If I could refer your Lordships to the case of Henthorne and Fraser, which we found on hyperlink 1 of your bundle. Would your Lordships care for a brief summary of the facts of the case?
Well, I think it might be just helpful to, very briefly, say what the context was in which the issue arose.
Yes, my Lord. There was an offer for the sale of property, which was said to be open for 14 days. The revocation was sent for this offer, however, was after acceptance was posted.
But the key characteristic, it seemed to me, was that there had been a course of dealing by post between the parties. Is
Indeed,
that
my
correct?
Lord. Indeed.
Right. But that's not the case here, is it?
No, my Lord, it is not. However, I submit that the principle is applicable in this case.
Very well.
If I could provide Lordships the judgment of Lord Herschel, who states that where the circumstances are such that it must have been within the contemplation of the parties that according to the ordinary usages of mankind, the post might be used as a means of communicating the acceptance of an offer. The acceptance is complete as soon as it is communicated, as soon as it is posted.
What do you think the words according to the ordinary usages of mankind mean?
My Lords, I submit that what Lord Herschel is saying at this point is what the reasonable person would have done, whether he would have accepted the offer via the postal service.
But this was a negotiation that had been conducted by telephone.
Indeed, my lady. However, I submit that the original offer was conducted by telephone. However, the acceptance was purported to be sent via the postal service.
But what at that point was there that would suggest that this was a case where, if I can use those words again, according to the ordinary usages of mankind, that the use of the post was in contemplation? So it had been negotiated by telephone. One of the parties had said that he was hoping to get £500 for the bike. Go away and think about it for a while.
Yes, my Lord.
And no doubt the parties exchanged phone numbers. I mean, we do know that the seller's phone number was available to the putative buyer because he telephoned him later in the week.
Yes, my Lords. However, my submission is that it was not in the reasonable contemplation of the parties. Therefore, the postal rule is inapplicable.
Okay.
My Lords, I submit that as Mandela stated that he was going on holiday and that he would think about the offer, there is an implied representation that he would not accept it whilst he was on holiday. My Lords, your Lordships, I submit that this means that it was not in the contemplation of the parties that the postal service would have been used. Also, as your Lordship has previously said, the previous conversations were by telephone. Therefore, this supports my submission.
Was it clear that the offer to buy the bike for £400 was actually still open, or were we not back to square one?
My Lords, I submit that it was clear that it was still open, as he did not openly reject the offer. However, he merely stated that he would think about it and get back to him later. If I could refer your Lordships to the next case, that of Carlisle and Carbolic Smokeball Company. Would your Lordships care for a brief summary?
Can you just tell us what proposition you're relying on that case for? Because that was about unilateral offers, and this case isn't a unilateral offer.
Indeed, my Lords. However, I'm relying on this case for my submission that as the postal rule is not applicable under the Henthorne principle, the Carlisle case outlines the proposition that acceptance must be notified. Therefore, if the postal rule is not effective, then then the acceptance was only correct once it had been received.
Okay, no, I take that point.
particularly the judgment of Justice Lindley, who outlines this on hyperlink 2 of your bundle, who states that unquestionably, as a general proposition, when an offer is made, it is necessary in order to make a binding contract, not only that it should be accepted, but that the acceptance should be notified. Your Lordships, I submit...
But it doesn't tell us in what form it should be notified, does it?
Indeed, my Lord. However, I submit that because the postal rule is not effective, then it relies on the general principle of the common law that acceptance must be received. Do you also have any further questions on the submission?
Not on Colin Cobbolt's monopoly.
Then, with your Lordship's permission, I shall move to my second submission, namely that, even if it were reasonable to accept by post, the postal rule does not apply, as it would lead to a manifest inconvenience or absurdity. If I could refer your Lordships to the case of Holwell Securities and Hughes, on hyperlink 3 of your bundle. Would your Lordships care for a brief summary?
I don't think so. I mean, this was another commercial case concerning an option to purchase property.
Indeed. Your Lordships, here, Lord Justice Lawton states that in my judgment, the factors of inconvenience and absurdity are but illustrations of a wider principle, namely that the rule does not apply if, having regard to all the circumstances, including the nature of the subject matter under consideration, the negotiating parties cannot have intended there should be a binding agreement until the party accepting an offer or exercising an option had in fact communicated the acceptance or exercise to the other.
This case is different to Holwell, isn't it? It's in Holwell, as it said that the acceptance should be received. I wait to hear from you. So it's implying that an acceptance should be received. That's not the case here, is it?
Indeed, my Lord. In Holwell, it states that, as I have just referred you to, it states that if there is a manifest inconvenience or absurdity, the postal rule should not apply.
Yes, it says manifest inconvenience or absurdity having regard to all the circumstances and the intention of the negotiating parties. There's nothing in the offer or the course of negotiations that we're aware of that's to give the impression that acceptance must be received, is there?
My Lords, I submit that due to the facts that this does constitute a manifest inconvenience.
How is it manifestly absurd?
My Lords, I submit that the application of the postal rule, in this case, would lead to a manifest inconvenience, as Mr. Mandela was on holiday, therefore he was incommunicado. I submit that as a matter of public policy, this application of postal rule would lead to uncertainty in contractual dealings.
But he wasn't incommunicado, was he? He elected to send the acceptance.
My Lords, I submit that no, my Lord, I'm referring to the fact that he is incommunicado for the appellant. The appellants could not reach him.
He didn't have a mobile phone.
It is unclear whether he had a mobile phone, my Lords. Therefore, I submit that we should not look into these details if they're not stated.
Indeed.
My Lordships, I further submit that as a matter of public policy, if an offeror may not contact the offeree as he is incommunicado, I submit that the exception to the postal rule under manifest inconvenience should be extended to this situation, as it is impossible to revoke the offer and it would cause uncertainty in contractual dealings, as there is no way to know whether the offer has been accepted or not, meaning that you cannot sell the product to a third party.
Well, could the seller have sold the bike for £500 if somebody had come along, if he'd met somebody on holiday who'd said, "Oh, I'm looking for a bike," the chap says, "Oh, I've got one, 500 quid.
Indeed, my Lord.
Would the seller, would Mr. Mandela have been able to sell his bike for £500 while he was on holiday?
Indeed, my Lords. However...
Oh, sorry, indeed isn't a yes or a no.
Yes, my Lord.
So he could.
Yes. However, my submission...
So the offer, he could terminate the possibility of accepting the offer of 400 by selling to somebody else. But the buyer wouldn't be able himself, if he found somebody willing to sell him a genuine limited edition Roadmaster for £300, he wouldn't have been able to buy it.
Yes, my Lord.
Isn't that manifestly absurd? That one party can have the benefit of getting a good deal, but the other party can't?
My Lords, I'm aware of the run out of time. May I have extra time to finish my submission.
You may tell me whether you think it's manifestly absurd, yes.
My lords, I submit that in contract dealings of this kind, it is more reasonable to place the burden on the offeree rather than the offeror, as the offeror is the person who is in the position of not knowing what the situation is in circumstances such as these.
Very well.
Do your lordships have any further questions arising from this submission?
No.
Then I shall move to my third and final submission, namely that as the postal rule
Very briefly.
Indeed,
You're
my
out
lord.
of time.
As the postal rule does not apply, the offer may be regarded as revoked from the point at which the voicemail was left, regardless of whether it had been heard. If I could refer your lordships the case of Tenax Steamship Company and owner of the motor vessel, the Brims, would your lordships care for a brief summary?
No, just refer us to the proposition that you're citing this case for, and then you will have to conclude.
My lordships, in this case, Lord Justice Edmund Davies states that if withdrawal is sent during ordinary business hours, it may be regarded as received, regardless of whether it has been read or not. I submit that in the current case, this principle should be extended outside of commercial dealings to dealings of this kind.
Thank you.
Do you have any further questions? Then I will hand over to my Lord Junior.
Your Lordships, I shall be making submissions on the second ground of appeal, namely that even if there are a valid contract, Gandhi is entitled to damages, as there was misrepresentation.
My first submission is...
Well, I'm actually going to stop you there, having had the benefit of seeing your skeleton, because it seems to me that you're approaching this issue in reverse order. It seems to me the starting point is the Misrepresentation Act. We now have a piece of legislation that deals with misrepresentations. So far as I can determine from the facts as found, this was an innocent misrepresentation, and in those circumstances the remedy is rescission or damages, and rescission would seem, in all the circumstances of the case, to be a perfectly satisfactory remedy. Where am I wrong on that, and why do we need to argue it in a different way?
Firstly, I respectfully submit that given the facts of the case, it is not possible to tell whether the representation was made negligently or whether it was made wholly innocently.
Well, if there is nothing to suggest it was anything other than innocent, mustn't we presume it was innocent?
Absolutely, my lady. And if we look at the Section 2.1 of the Misrepresentation Act, it does not differ between innocent representation and that of fraudulence.
It does in terms of remedies.
Absolutely, my lord. And I will be coming to that in my third line of submission.
So are you proceeding on the basis that this was an innocent misrepresentation?
No, my lord.
So what evidence have we got that it... Certainly no evidence that it was fraudulent.
No, absolutely, my lord.
So what evidence is there that it was negligent?
Firstly, my lord, we make with the statement that was made by the respondent. We believe the appellant submits that with the experience of the respondent, he has 5 years worth of cycling experience, that it would be extremely unreasonable for him not to know the difference between his own bike, which he believes is a limited edition, than that of what is not, and is actually worth a fifth of the amount that he believes it is.
Very well. It does seem to me, however, that you're clutching at straws a little to show negligent misrepresentation.
Okay. My lord,
I mean, we're told later on that Mandel has maintained he's not a bike expert. He genuinely believed the bike to be a limited edition. Perhaps his recollection, when he bought this bike 5 years ago, was that he bought a limited edition Roadmaster.
absolutely. We cannot make the assumption as making that statement would be in favour of the respondent, as not actually possible to tell what his true beliefs were at the time. So if I may go on to my first submission, which would outline the statement of a false statement. If a person chooses to state information as fact, it is a representation of the matter stated regardless of whether the representative truly believed the statement, and therefore it is actionable. For this line of submission, I'll refer to the case of Attorney General and Ray, which is found on hyperlink 5 of the e-bundle provided.
And what was the misrepresentation? We don't need the facts.
The misrepresentation.
Insofar as it's necessary to explain what the misrepresentation was. But what was the misrepresentation in this case?
That it was a limited edition bike, and that the price that it was, that the going price for the bicycle was.
No, in Attorney General of Rep.
Oh, in Attorney General. Attorney General was a case of life insurance for the Commission to pay out a grant to a life insurance firm. This was based on a particular gentleman named C in the case, that he was the age of 64 and he was deceased. Turns out neither of the statements were actually true, and therefore were misrepresentations.
So whether or not somebody is deceased or not is usually pretty easy to tell.
Absolutely.
Okay.
My Lord, I quote from the case as of the judgment of Sir W.M. James, Lord Justice. It is impossible to allow persons in this court to escape the effect of such positive representations of matters of fact upon the ground that they relied upon the representations made to them by their own agents, employed by them for the purpose of getting information for them. If a man makes a statement based upon the information which he has received from another, and the information is wrong, he is answerable for it, but he has his remedy over the person who has deceived him. Your Lordships, I submit that regardless of the statement, whether he believed it to be fact or not, he has therefore made it and undertaken the statement, and so therefore he should be liable for any consequences flowing from this act.
Well, except that the Misrepresentation Act makes a distinction between innocent, negligent and fraudulent misrepresentation.
Yes, my Lord. With the Misrepresentation Act, these are statements of belief or statements given. This is a statement of fact given by the respondent that he is stating, and should therefore, under the authority provided, he should be liable for.
Okay, well, proceed.
Your Lordships, if you have no further questions regarding this line of submission, I'd like to move on to my second.
Yeah, please do.
Thank you. Your Lordships, I submit that the false statement of fact can be regarded as material, shifting the onus of proof onto the respondent to disprove inducement. To the reasonable man, it is to believe before making a purchase of this nature regarding the value of what his purchase ultimately ends up to be.
Is there anything in the facts to suggest to us that the buyer in this case particularly wanted a limited edition bike?
Your Lordship, respectfully, I'll submit that...
Sorry, my question is there anything in the facts that indicate that the buyer in this case particularly wanted a limited edition bike?
No, there isn't, my Lord.
No, he knew nothing about it, he just wanted something that looked like it'd be okay to use, go about his business on.
Respectfully, Your Lordship, I submit that the reasonable man, which is given in the case of Muse Prime Properties Limited and Ad Hill Properties Limited.
And what was the misrepresentation in that case?
The misrepresentation was the statement of rent that was owed for members attending an auction of 3 different properties.
So again, we're in the commercial field,
Yes,
and the misrepresentation was effectively that the buyer had been led to believe that the rents on the property he was buying were still negotiable, when in fact they were not.
Respectfully,
So in those circumstances, it's clearly important to a person investing in property that he's going to be able to maximise his income. Again, I struggle to see how that really assists in the context of this small consumer purchase that we're looking at here, where the buyer isn't particularly worried. He said the one that he was advertising sounded suitable. We're not told he set his heart on getting a limited edition Roadmaster, and here was one, and they don't come up very often. So in the sense that I'm not quite clear what the inducement is that you're suggesting here.
Absolutely, my Lord. With the authority of Muse Prime Properties, I submit that the principle given in which that I am about to explain is actually that that can continue outside of that of a commercial nature and that into everyday common law regarding contractual purchases.
But even if we accept that, and I don't have any particular difficulty in accepting that, I still fail to see how the potential buyer here has been induced to enter into this contract by the description of the bike as a limited edition Roadmaster. It's clearly been on the receiving end of a misstatement about the nature of the bike, but has he been induced by the fact that it's been described as a limited edition Roadmaster when it isn't a limited edition, but is an ordinary edition Roadmaster?
Absolutely, my Lord. I'll continue answering questions. I may request for additional time, which I will move swiftly.
Just keep it snappy at this
Absolutely.
point.
So the principle given in the case of Muse Prime is not that it's for the appellant to prove that he was in fact induced. But if there is materiality to the inducement, then this shifts the onus of proof, of proving inducement from that of the appellant and onto that of the respondent.
I certainly accept the legal proposition. What I'm rather struggling with is whether it's material in this case. So I suggest you move on to your third head of argument as set out in the skeleton.
Yes, my lord. My final submission, as I'll move swiftly on to, is that damages are owed along with rescission as a result of misrepresentation, despite there being no pecuniary loss. I won't go into the details.
So your client wants damages rather than rescission if we conclude that this is an innocent misrepresentation?
The appellant is submitting that they would wish for both.
But can they have both if it's an innocent misrepresentation?
Yes, my lord.
I don't think that's correct.
Okay, so if I may,
So tell us what the significance of Archer and Brown.
So Archer and Brown gives a principle, I assume you're familiar with the cases, my lordships, of regardless of, if it's best explained in the quote of Lord Justice Widgery, if I may go on to state. A hyperlink 8 of the bundle.
That's a case of fraudulent misrepresentation, isn't it?
Yes, and with the Misrepresentation Act, we are able, it is indistinguishable between fraudulent and negligent, which the appellant is claiming for. So the case of Archer and Brown, it says regardless of the of how the misrepresentation acted upon the appellant, if there is an inconvenience that is acted upon the appellant, damages are available to claim, however small they are.
But this case is about exemplary damages, isn't it? Are you asking for exemplary damages in this case?
In the result of Archer and Brown, there is a damages of £100 for the inconvenience given. So the principle can still be related to the case at hand, my lady.
But the passage to which you're referring as to is immediately under a heading called damages for injured feelings. Are you suggesting that there were injured feelings here?
I'm submitting that injured feelings would also come on inconvenience of wasted time and bother occurred to the appellant would come under that heading.
Okay, thank you.
If your lordships have no further questions, the appellant respectfully submits this appeal be allowed.
Thank you, Mr. Butler.
Thank you, your lordships.
Yes, Mr. Chairman,
Your Lordships, I shall respectfully invite you to find in favour of the respondent the following lines of submission for a first ground: that a valid contract had been formed as acceptance had been successfully communicated by Mr. Mandela. Firstly, following the ruling of the court at first instance, a valid contract had been formed the moment the respondent posted the postcard. In support of this submission, if with your Lordship's permission I may dispense of future citations. In support of this submission, if I may refer your Lordship's attention to the case of Adams and Linsell, which can be found hyperlink 1 of your bundle, or page 3. Do your Lordships require a summary of the facts?
I don't think we do, but I think what would be helpful in addressing this case before you go to the specific passage is clearly you're basing your case on the fact that a contract, it was in the contemplation of the parties here that the contract should be completed by using postal means.
Yes, my Lord.
And I think it would be helpful to know the basis on which, given that the initial communication was by telephone, the subsequent attempt to withdraw was by telephone, what it is that makes the application of the postal rules appropriate in this case.
My Lord, in this case...
sorry, just to be clear, is it a default position, or is it one where one looks at all the circumstances of the case and determines whether that's...
My Lord, it is one that can only be determined by the circumstances of the case, and it is one which I will determine to your Lordships upon close consideration of the facts of the case, that it must have been contemplation between both parties. And I will enumerate certain factors to show you such.
Can you state very briefly, because I don't want to eat into too much of your time, what that argument is, that postal communication was in the contemplation of the parties? Because I see very little in the facts that indicates that the parties had made any consideration of the forms of communication here.
My Lord, the argument that we are submitting is that the usage of the postal rule was the best available option that Mr. Mandela had, and I am basing this argument on the following factors. Firstly, that Mr. Mandela indicated that he would be leaving town. Therefore, an alternate method of communication would need to be arranged. Secondly, it would be in Mr. Mandela's best option, had he had access perhaps to a cell phone or any other means of communication, to use such means to accept his offer, as he's the one who is willing to sell the bike, and he's the one who is looking to secure the transaction.
As far as I'm aware, it's 2015. People don't communicate by post. We certainly don't enter into contracts for relatively modest items by using postal means. It's an era of mobile phones, email. If one doesn't have those forms of communication, perhaps
My Lord.
Perhaps the seller could have said, here's where I'm going on holiday, you'll be able to contact me there. There's nothing to indicate that they didn't simply go away, having had this telephone conversation with Mandela selling Gandhi, oh, that's not as much as I was hoping to get, I'll think about it while I'm away.
My Lord, I submit
that's not enough for me to bring in the postal rule.
My Lord, I submit the alternative that given his conduct and the fact that he did not check his answering machine, and that he then went on to submit his acceptance by post, that the post must have been the only available option for him to communicate his acceptance.
But does it have to, is it a two-way street or a one-way street? So can one party decide that the postal rules apply?
My Lord, this is taken into consideration the contemplation of both parties. However, what one party may decide is to omit this rule entirely. My learned friends have made use of the case of Howell Securities, where the offerer may simply omit this rule if, as my learned friends have stated, he may be incommunicado. In this case, the offerer did not omit the rule, and given the factors of this case, firstly, of his consistent conduct of not checking his answering machine, of leaving town, and of course...
consistent, couldn't check his answering machine because he was away on holiday.
My Lord, if he was away on holiday, he clearly stated that he would be on holiday. This was not a matter of neglect or a matter where the offerer was left in the blue. He had made clear intention to the offerer that I would be on holiday. Therefore, perhaps I would not have access to any means of communication.
Well, again, it would be helpful if we got clearer stipulated facts, but it's certainly possible to obtain messages on your answering machine remotely.
Yes, my Lord, but what we do know is that Mr. Mandela did have the access, Mr. Mandela had access of Mr. Gandhi's address. We contend that if he had Mr. Gandhi's address, then given such, it must have been contemplated during their initial phone conversation, or at some point, that the use of post would indeed come in effect.
That's your strongest point so far.
Thank you, my Lord. And taking these factors into consideration, I submit that acceptance by post was reasonable in accordance to the ordinary usages of mankind if these were the only available resources that he had on hand, and there is nothing in the facts of the case which would dictate otherwise. Now, my learned friends have referenced the case of Carlisle and Cargolic Smokeball in saying that the communication of the offer must mirror that of the acceptance. However, that is not the law in consideration of our facts, as there was no specific mention of how the offer, how the acceptance should be communicated. If I may direct your Lordship's attention to the case of Henthorne and Fraser, which may be found hyperlink 3 of your bundle, or page 55, where Lord Justice Lindley, as he then was, held in his dictum. I quite concur. I am not prepared to accede to the argument that because the offer was not made by post, there was no authority to send acceptance by post. If I may illustrate Lord Justice Lindley's words, suppose, for example, that Mr. Mandela had run into Mr. Gandhi at Tesco while shopping for groceries and said, I accept your offer here and there. It would be quite silly for Mr. Gandhi to say, no, you are not allowed, as I had telephoned you. Therefore, you must go back home and call me to accept. If there are no further questions with your Lordships, may I move to my next line of submission?
Please do.
My learned friends have submitted that revocation ought to take place whether or not the message had been heard. However, this is not the general rule, but only an exception, which is highly limited to its specific context, namely that of business. If I may refer your Lordship's attention to the case of the Brims, which my learned friends have already cited. On hyperlink 5 of your bundle, or page 58, Lord Justice Miga, in his judgment, if I may paraphrase, that in the ordinary courses of business dealing, where ordinary business hours are held, it is of irrelevance whether or not the party had checked the message. It is still deemed to have been communicated. And applying the brims to our case, we find that it is easily distinguishable on our facts, as the brims pertain to a commercial and business setting, whereas in our scenario, it revolves around a domestic one. As such, no ordinary business hours could be held to a domestic setting. In business, we know that there are the familiar hours of 8 to 4 and 9 to 5, but this is obviously not the case within a person's own setting.
In saying that, are you conceding that in a contractual arrangement like this, which is between two consumers, two private parties, that different considerations should apply than in cases where the parties, or one of the parties, is in business?
My lord, as far as we are concerned by the fact, neither of these parties are in business. Therefore, relating your question to the facts where both are consumers, there is a way to handle that, and that is by the general rule of Bern Vink and Hoven, which I will get to after I have distinguished the case of the brims to our facts.
So that's a long answer, which doesn't appear to respond to my question, which is, are you conceding that different principles might well apply to contracts between two consumers than to contracts between business people or between one business partner and a consumer? And your previous argument was based on the fact that we should make a distinction.
Yes, we should.
And what I'm really trying to tease out is whether that's a general proposition or an isolated proposition, whether you're simply cherry picking.
That is a general proposition. It is the general rule, my lord. And
Well, sorry, if
the
it's
brims
if
is
it's a
simply an
general
exception.
rule, what authority is it?
The authority that I'll be citing is the case of Bern Vink and Hoven.
Well, then proceed to cite it, but that, it seems to me, is a contract, was a commercial contract for 1,000 boxes of tin plates, if I remember correctly. But yes, do proceed then and see whether you can persuade me.
If I may refer your lordship's attention to the case of Bern Company and Vink and Hoven, which can be found hyperlink 4 of your bundle, or page 15. Do your lordship require a summary of the facts?
No, but I do want some assistance, because
Yes.
the first three words of this quotation say, but this principle. And I'd like to know what this principle is.
But this principle appears to be inapplicable to the case. The principle that he is speaking about is the postal rule. Before I continue to explain my judgment, may I gain a lapse of time to finish my submission?
Again, as long as you are very brief.
Now, my lord, what is important to know is that the case of Bern dealt specifically with how to revoke an offer that was made by, dealt specifically with the revocation in the case of the postal rule.
The judge here is referring to a principle.
Yes, and the principle that he's referring is that revocation will only take effect once it is communicated to the other party. And that being said, given that it was never communicated to Mr. Mandela, as it had never come to his attention, there could be no effective revocation.
Fine.
That is the general rule that I submit, my lord.
Yep.
And saying that, in my last submission, very briefly, if your lordships wish to displace with the postal rule, and if your lordships agree that there was no revocation of offer, then we're back to square one, where the offer remains open. In this case, I turn to the authority that, my apologies, in this case I submit that acceptance was communicated to the appellant upon delivery of the bike. At that time, a valid contract had been formed. In support of this submission, if I may refer your lordship's case to On Tours and Miles Far East, which can be found hyperlink 6 or page 70 of your bundle. Where Lord Justice Denning, as he then was, held in his judgment, if I may paraphrase, the contract is only complete when acceptance is received by the offerer, and the contract is made at the place where the acceptance is received. And applying this to our case, given that revocation had never been received or communicated to Mr. Mandela, the contract, my apologies, the offer remains open. Therefore, I submit that upon delivering the bike to Mr. Gandhi's house, he had explicitly communicated acceptance by saying, "Hello, here I am, and here is the bike to the offer that you have made," therefore rendering both parties into a valid contract.
Doesn't that cause difficulties? If you hold that's the rule and you're going to apply it to small claims such as these, where you have adverts placed in shop windows or in newspapers, doesn't that pose difficulties where you have fraudulent tradesmen? Because if that's the rule, what's to stop a crook posting an advert in a shop window or in the small ads bit of a paper and then if somebody phones up, they say, let me think about it. And then they wait a week, or they go on holiday or whatever. They send a postcard, or they don't even need to send a postcard. They just have to say, we sent a postcard. And then they turn up at the person's house with the goods and say, ta-da, here you are, concluded contract.
My lady.
It seems to me that if you apply that rule more generally, it's an absolute gift for the petty fraudster.
My lady, if we were to follow your scenario, I would completely agree, but before going that far into the outcome, where he had placed an ad, all he had done is place an ad, he didn't make an offer. Therefore, the offerer, Mr. Mandela, my apologies, Mr. Gandhi, could have went and inspected the bike, made inquiries about the bike before he was ready to make an offer. There was nothing that Mr. Mandela said in the ad that said, hey, you are not allowed to see the bike. The only way that you could see it is if you make an offer. That is not the case. Mr. Gandhi was open to checking the bike, to inspecting the bike, and to then making a reasonable decision as to whether or not he would extend an offer. But he did not do so.
I think in the interest of time we should stop there. I do have another question, but I will hold fire.
If there are no further questions, the respondents submit that the appeal be dismissed.
Well, I think we're going to hear
We're
from
going
your
to-
junior
yes.
before we get to that point.
And my junior will elaborate on the second ground.
Yes, thank you.
My own friends based their first submission on the grounds that the appellant submitted that acceptance, the method of acceptance should mirror the method of the offer. That is simply not the case. We did not submit that, and I submit that they are misleading your lordships as to the appellant's submissions. Secondly, as to whether the substantial correctness, there are 2 points arising from this. Firstly, that the advert was not substantially correct. The majority of the description of the bicycle was wrong. Secondly, my learned friends apply 2 authorities. Firstly, Webster and Lillington, and secondly, Avon Insurance. These authorities are contradictory. In the first case, in the Webster case, it stated that the useless solution only had 0.3% of the harmful substance. However, although it was substantially correct, it had none of the substance. It was done actionable misrepresentation. Your Lordships, I submit that this judgment brings into question the ruling in Avon. Thirdly and finally, as your Lordships stated, the representation was factually incorrect. There was a misrepresentation. And my learned friend submitted that they were not that the respondent was not in a position to know about the bicycle. However, he had been cycling for many years, so he should have had some kinds of idea about it.
What do you say about this implied disclaimer in relation to classified advertisements, that you basically don't believe a word they say?
My lady may have some extra
Just
comments.
answer my
Thank you.
question briefly.
My lady, I submit that I'm not entirely clear on this area of the law. However, I submit that on public policy grounds, it would seem unfair to allow an advertisement that is factually incorrect to still be binding, just because the person answering it has not checked the article in question.
No.
Little conference might jump. Have you anything further to add?
No, my lord.
Right. Have any questions?
No.
Thank you.
Thank you.
All rise.
Please be seated. Firstly, just a brief word on the law. We're not going to give a judgment, although Lord Justice Nile on my left has written a judgment, but I'm afraid that the two of us on this side don't agree with it.
So there's a difference of opinion in relation to whether or not the postal rules apply. But what we are going to do is just make a few general comments to begin with about mooting, and then we will announce the winner. So we build up the pressure a little bit in this stage. I always enjoy coming back to these moots because I'm impressed with the way in which the finalists in this competition deal with a big formal occasion. I don't know whether you've had audiences like this in earlier rounds, I suspect not. And you've got me as this outsider coming along to be nasty to you. I try not to be nasty. I'm not a nasty judge. At least I don't think I'm a nasty judge. I think in my sittings, the Secretary of State sometimes thinks that I have my own view of the law. And I know that by the times that I've been taken to the Court of Appeal. And the score so far is 2-2. There's a big case at the moment that when I was one of 3 judges at first instance that went to the Court of Appeal. The Court of Appeal agreed with us. It went to the Supreme Court. The Supreme Court's decided it can't answer the question without referring questions to the European Court of Justice. So I'm on tenterhooks now waiting to see what the European Court of Justice says in response to the questions. These cases are always slightly more worrisome to me, since when I was here, I was a professor of European law, and when counsel for the respondents who in the Supreme Court pointed out to Lady Hale and the 4 other Supreme Court judges that this upper tribunal decision, which was effectively the one that was before them, included Professor White, and he's a professor of European law. And the look on the faces of the judges was steely blank. I don't think it was a point that particularly impressed them. But we'll see what the European Court of Justice makes of that. But to return to your performance, I have seen counsel appearing before me in the upper tribunal, and we don't do many, I don't do as part-timer many oral hearings, but I've seen counsel do a lot worse than the 4 of you did today. So that's a real compliment, because we don't get hopeless performances before us in the upper tribunal. We do occasionally get counsel or representatives who won't let go of a point which they should let go of, and I think you all, in some point or another, demonstrated that there were points that you should have let go of, that you held on to a little too long. That's not really a criticism, because when you're on your feet, it's really difficult. When you've got a case that you've got to argue, you don't want inadvertently to give it away. The final point I think I would make generally is to remember that whatever the outcome today, we're actually talking about the 2 best teams, so the 4 best mooters, out of all those who started in this competition some time ago. So I think I would want to congratulate all of you. None of you dried up. All of you stood up to firm questioning, and that is much to be commended. So I'm going to stop there and let either Oliver or Tracy say that.
Yes, we're impressed. We're fairly happy. We may not look like we're fairly happy most of the time, but I assure you we are. No, it's good, and you guys have been through enough of these moots that you know what's good and what isn't, and you've come a long way since Tracy and I saw you doing moots this time last year and slightly thereafter, so well done. Some of you are still using scripts, and you know we need to bin those. Some of you are more scripted than others, you need to get shot of them. You need to learn to enjoy it when a judge takes you away from the plan. When a judge says, you've put this point as 3rd, I want to hear it first. That's good fun. We're toying with you, we're testing you.
That's not good fun.
Terrifying. Enjoy the challenge and expect that in your preparation. Those of you who are going to do mooting, expect that and enjoy being tested.
Well, interrupting there, you do have to be aware of what is known in the vernacular as being stitched up like a kipper by the Court of Appeal. They're very good at what they do is they say, let's look at ground 3. That's your best point, isn't it? So you say, yes. And they then destroy it and say, well, that was your best point, there's nothing really in the other 2. You can find your appeal dismissed before you can say knife, so you do have to be a little careful. Sorry, Oliver.
No, quite right. And I think I'm going to give one big bit of feedback, and that's this. If you're asked a question, answer it. Don't give me all the waffle, all the extra stuff. Just answer the question. You'll make your point better, it will be more concise, it will carry more weight, and I'm more likely to be persuaded by it. If you need a moment to think about the answer, take it. Take a sip of water or something to buy yourself a couple of extra seconds to work out what it is you're going to say.
Ask the judge to repeat the question, that buys you time.
Only once, otherwise get really tipped off. Answer the question. Clear, concise, robust. That's what we want.
Robin.
No,
I finished.
Oh, right, okay. Well, this is the moment that we've all been waiting for. We didn't find it particularly difficult. Sometimes we do. Sometimes I sat here and we've cogitated for a long time as to who has won the moot. But on this occasion, we were quickly unanimous that the winners of this moot were the counsel for the appellants. So congratulations to counsel for the appellants. Congratulations to the runners-up.